I want to start today by asking you a question. It's a bit of a hypothetical, but just stick with me for a second.
Okay, I'm with you.
I want you to think about the last story you told. I mean, it could be anything. Maybe a joke at a dinner party. Maybe it was, a bedtime story you made up for your kids about a squirrel who lost his nuts.
Yeah.
Or maybe it was just a funny anecdote you typed out in a group chat.
Okay, got it. I'm picturing it.
Now imagine if right before you got to the punchline, or maybe right before you hit send, a lawyer just steps out of the shadows.
Oh.
Yeah. He's wearing a nice suit, holding a briefcase, and he hands you a bill. He tells you that the joke you're about to tell, it uses a narrative structure that's currently owned by a media conglomerate.
Oh, wow.
And if you want to finish that sentence, you owe them a licensing fee.
That sounds like a dystopian nightmare. Or, I don't know, a really bad sketch comedy skit.
It sounds absurd, right?
Of course.
Because we think of stories like air. They're just free. They're out there. We breathe them in, we breathe them out. You can't own the air.
But today's deep dive is going to challenge that very assumption. Because that air, it's getting thinner.
We are looking at a really, really provocative set of sources today. The main one is an article titled The Bargain We Broke by Dixon Kinqade. And we're also pulling from this raw text file that was part of the research packet, just labeled untitled.txt. And these documents, they argue that we have slowly, very quietly, allowed the ownership of our own imagination to just be sold off.
It's a heavy claim, a really heavy claim. But when you look at the history, which we are absolutely going to do, it's hard to argue against it.
So on the surface, we are talking about copyright. And I know, copyright sounds like the driest, most boring, dusty legal topic imaginable. It sounds like the terms and conditions you scroll past just to get to the I agree button.
It usually puts people to sleep in law school, let alone, in a conversation like this.
Exactly. And this is where it gets really interesting. This isn't a story about lawyers or paperwork. The source calls it a story about a broken bargain. It's a story about Mickey Mouse. It's a story about something called the rentier class. And ultimately, it is a story about who owns our culture. Who owns the building blocks of the things we all create?
And the mission for this deep dive, if we want to call it that, is really to uncover how a system that was originally designed to share ideas, to literally force them into public hands, was transformed into a mechanism to hoard them.
And what that means for anyone who reads or writes or watches movies or, just exists in society.
Which is all of us.
So let's start with that framing device that the author uses.
Yeah.
The bargain. Because I think most people today, and I'd include myself in this until I read this material, have a very specific intuition about ownership.
Right.
If I build a chair, I own that chair. It's mine. I can sell it. I can burn it. I can leave it to my kids. If I build a house, it's my property. So if I write a book, isn't that just property?
That is the modern intuition, yes. Absolutely. We have been trained to think of intellectual property, IP, as a kind of birthright. You made it, so you own it forever, and nobody can touch it without your permission.
It feels like a natural right.
It feels like a natural right, like the right to free speech or something.
But the source material says this is just historically wrong.
Completely wrong, yeah. Kinqade argues that intellectual property wasn't originally conceived of as property in that absolute physical sense at all. It was a deal. A specific, calculated transaction between the creator and the public.
Okay, so let's look at the terms of this deal. Who's signing what here?
On one side of the table, you have the public, society as a whole. On the other side, you have the author or the inventor. The public basically says, okay, we want you to write that book. We want you to invent that steam engine. That stuff is good for us, for society. So to get you to do it, to incentivize you, we will grant you a monopoly.
Monopoly. That's kind of a dirty word usually.
It is. And the founders knew that. They were deeply suspicious of monopolies, but they said, look, we will give you the exclusive right to profit from your work for a time. You are the only one who can sell it. You're the only one who can copy it.
That's the carrot.
That's the carrot. But, and this is the massive but that we have completely forgotten, that monopoly is temporary. It has an expiration date. And once that clock runs out, your work, it belongs to us.
To the public.
Yes. It enters what's called the cultural commons. It enters the public domain. So the deal is you get paid for a while, and in exchange, society gets a new permanent addition to its library of culture. You're basically renting the idea from the public. You don't own it outright forever.
That is a fundamental shift in perspective. I'm not the permanent owner of the castle. I'm just leasing the land for a little bit.
Exactly. That's a perfect way to put it.
And I really want to get into the weeds here because the contrast is just, it's shocking. If we look at the time limit on this deal when the country was founded versus the time limit today, it's like we're talking about two different universes. It really, really is.
So let's go back. Let's go back to the beginning. Section 1, the original vision, or as our outline calls it, the elegant bargain. Take us back to 1790. What was a vibe? What were they thinking?
Well, to understand the vibe, you really have to look at the bedrock, the U.S. Constitution.
Right.
Specifically, it's Article 1, Section 8, Clause 8.
Okay, I feel like we should be wearing powdered wigs for this part.
It probably wouldn't hurt, but you have to remember, the men writing this document, Madison, Jefferson, Franklin, these were Enlightenment thinkers. They were obsessed with the spread of knowledge, but they were also deeply, deeply suspicious of concentrated power.
Right. They just fought a whole war to get away from a king. They didn't like unchecked power in any form.
And they specifically hated monopolies. I mean, remember, the Boston Tea Party wasn't just about taxes. It was about the East India Company having a state-sponsored monopoly on tea.
Good point.
They viewed monopolies as dangerous. They inflate prices. They hurt consumers. They stifle competition and innovation. So writing a monopoly into the Constitution seems like a really weird move for them to make.
It was a necessary evil. That's how they saw it. And because it was a necessary evil, they put a very, very tight leash on it. And the text of the Constitution here is fascinating because it's the only place in the whole document where they explain why they're granting a power.
Oh, interesting. What does the text actually say?
It says Congress has the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries.
Okay, let's break that down. To promote the progress of science and useful arts.
That's the mission statement. Right there. That is the why. The goal wasn't to make authors rich. I mean, if authors got rich along the way, that was fine. It was a nice side effect. But it wasn't the point.
The point was progress.
The point was progress. They wanted to fill the libraries. They wanted to educate the populace. They wanted better maps, better navigational tools, better political pamphlets to debate.
So if a copyright law doesn't actually promote progress, it's arguably failing its entire constitutional purpose.
Precisely. The exclusive right, the copyright itself, was just the mechanism. It was the engine, not the destination. And the Constitution explicitly adds two words that change absolutely everything. Limited times.
Limited times. It's right there in the text.
They were crystal clear. They didn't say forever. They didn't say for as long as the author wants or for as long as their kids want. They said limited.
So let's get down to the math of 1790. The very first Copyright Act is passed. I'm a writer in Philadelphia in, say, 1790. I just wrote a pamphlet about, I don't know, new farming techniques. How long do I own it?
14 years.
14 years. That's it.
That was the initial term, 14, 1-4.
That seems incredibly short. I mean, my car loan is longer than that. My mortgage is 30 years.
Well, think about the context of 1790. 14 years was a pretty long time. It was the standard length of an apprenticeship. It was enough time for a whole generation to grow up. But more importantly, it reflected what they wanted, which was velocity.
Velocity of information.
Yes. They wanted the work to hit the market. The author makes their profit from the initial sales, and then boom, it becomes public property so everyone else can use it, learn from it, build on it.
Okay. Now, was there a renewal option? Could you get more time?
Yes, there was one. If you, the author, were still alive at the end of that 14 years.
Only if you were still alive.
Only if you were still alive. You could renew for another 14 years.
Okay, so 14 plus 14, that's 28 years.
28 years was the absolute hard cap, the maximum. Even if you lived to be 100, it didn't matter. After 28 years, your work entered the public domain. No exceptions.
I want to pause on that term, public domain, because we're going to use it a lot. And I think when people hear public domain, they think of, I don't know, dusty old books in a library basement.
Mm-hmm.
Or maybe they think of, like, cheesy clip art from the 90s.
Right, generic stock photo, that kind of thing.
But in this context, how should we be defining it? What did it mean to them?
You should think of the public domain as the cultural commons. Imagine a town square where there's just a giant open pile of building materials.
Okay.
Bricks, wood, glass, everything you need. Anyone in town can just walk up to that pile, take whatever they need, and go build something. You don't have to ask the mayor. You don't have to pay a fee. You just take it and you build.
And the materials in this case are the stories, the characters, the songs, the inventions.
Exactly. The public domain is the space where anyone can take a work, they can reprint it, perform it, adapt it into a movie, remix it into a song, or build a sequel to it, anything.
So back in 1790, if I wrote a book, 28 years later, literally anyone could just go print their own copy and sell it.
Yes. Or write a sequel where your main character goes to Mars. Or turn it into a stage play in Boston. The idea was that you had your turn to profit. You got to build your castle and live in it for a while. But eventually, that castle has to dissolve back into bricks, and those bricks go back into the pile for the next kid to use.
That's a great analogy. The building blocks of culture.
It really is. And this wasn't an accident. The expert analysis in our source material really emphasizes that the framers understood this deep philosophical truth about creativity. All work builds on what came before.
Right. I mean, you don't invent the English language every time you write a sentence. You don't invent the concept of a tragedy or a comedy. You were using tools that were handed down to you.
Precisely. It's like that famous Newton quote, "If I have seen further, it is by standing on the shoulders of giants." The 1790 law was designed to make sure those giants didn't charge you rent for standing on their shoulders.
That is the elegant bargain. 14 years, maybe 28 if you're lucky. Then it's ours. It feels clean, it feels fair and balanced.
It was a balance. It respected the author, but it ultimately prioritized the public good.
Okay, now, let's fast forward. Let's look at section 2, how we lost the plot. Because if I write a book today, in this decade, the rules are slightly different.
We are definitely not in Kansas anymore, no.
What are the numbers today? Lay it on us.
Today, thanks mostly to the Copyright Term Extension Act of 1998, the term for an individual author is the entire life of the author,
Yep.
plus 70 years after their death.
Life, plus 70.
Yes.
Okay, let's do the math on that for a second. Let's say I write a best-selling novel when I'm 30, and I'm healthy, I live to be 90.
Okay.
So that's 60 years of my life where the book is protected.
Plus 70 more years after you die.
So that's 130 years of copyright protection. That's not a limited time. That's geological time.
It's effectively perpetual. I mean, it spans multiple generations. Your great-grandchildren will likely be dead before that book enters the public domain.
And what about for corporations? Because a corporation doesn't die. You know, Disney doesn't have a life expectancy.
Right. For corporate works, what the law calls works for hire, it's a flat 95 years from the date of publication.
95 years, so almost a full century.
Almost a century, yes.
And this, of course, brings us to the mouse in the room. You cannot talk about copyright extension without talking about Mickey Mouse.
He's the mascot of the whole debate.
Our source material, The Bargain We Broke, brings this up specifically. Mickey was created in 1928 in Steamboat Willie. You know, the one where he's whistling on the boat?
Oh yeah, iconic image. Everyone knows it.
Now, under the old rules, even under the rules that existed in the early 20th century, which had already been extended a bit from the original, when should Mickey have entered the public domain?
Under the laws that were operating back then, Mickey Mouse should have been free for everyone to use by 1984.
1984. Orwell's here, yep. The irony is not lost. I was alive in 1984. I was a kid. If that had actually happened, I could have, drawn a Mickey Mouse comic and sold it at a lemonade stand?
You or Marvel or Warner Brothers or some indie filmmaker in their garage, anyone could have taken that original 1928 version of Mickey and put him in a movie.
But obviously that did not happen. Mickey is still very, very much under lock and key.
He is. Because every time Mickey got close to that expiration date, something, let's call it magical, happened in Washington, D.C.
Magical, right.
Or expensive, depending on how you look at it. Disney, along with a coalition of other major rights holders, lobbied Congress aggressively to extend the copyright terms. They did it in a big way in 1976, and then they did it again in 1998.
And the 1998 one is the famous one.
That's the Copyright Term Extension Act. But its nickname among critics, including Dixon Kinqade in our source, is the Mickey Mouse Protection Act.
Because the timing was just a little too perfect. Mickey was just about to expire, and suddenly, boom, here's another 20 years tacked on.
Exactly. It was not a coincidence.
Okay, I want to play devil's advocate here for a second.
Yeah.
Because I can hear a listener saying, so what? It's Mickey Mouse. Disney created him. They nurture the brand. If Mickey goes into the public domain, you're going to have, I don't know, slasher films starring Mickey Mouse.
Which we're starting to see now, actually.
Right. You're going to get low-quality knockoffs. Isn't there an argument that Disney is protecting the integrity of the character by keeping him locked up?
That is the stewardship argument. And it is a very, very seductive argument. It says, We take better care of this cultural property than the mob ever could.
It prevents brand dilution.
That's the claim. But our source it tears that argument apart. Kinqade argues that integrity is often just a code word for monopoly control. I mean, look at characters that are in the public domain: Sherlock Holmes, Dracula, Frankenstein's monster.
Okay, sure.
Are there bad Dracula movies out there?
Absolutely. Some of the worst movies ever made.
Are there terrible Sherlock Holmes adaptations?
Hundreds of them.
Right. But has that destroyed the character of Sherlock Holmes? Not at all. We also got the BBC Sherlock with Benedict Cumberbatch. We got the Robert Downey Jr. movies. We got Elementary. The character thrives because he can be endlessly reimagined. Culture survives the bad remixes.
So the argument is that Disney isn't protecting Mickey's integrity. They're protecting their multi-billion-dollar revenue stream.
Exactly. Disney just wants to avoid competition. If anyone can make a high-quality Mickey cartoon, then Disney has to compete on quality, not just on the basis of exclusive ownership.
And this whole shift from 28 years to 95 years, it represents a really fundamental change in the entire philosophy of copyright.
It absolutely does. In the 20th century, we stopped treating copyright as a limited incentive to get people to create new things. We started treating it as a perpetual stranglehold.
A stranglehold, that's a strong word.
It is. The argument from the source is that this shift creates an artificial scarcity of ideas. It treats our shared culture like private property that should never, ever be given back. It completely violates that original constitutional intent of promoting progress by ensuring that almost nothing ever really belongs to the public anymore.
It's like we all decided that the castle never has to crumble. The bricks never go back in the pile.
And if the bricks never go back in the pile, the playground gets very, very quiet.
So this begs the obvious question. Who did this? I mean, who changed the rules? That's what we need to look at in Section 3, the architects of this shift, because these laws don't just change themselves.
No, they do not. This is the follow the money portion of our deep dive.
Right, because when you hear about copyright extension, when you see the ads or the op-eds, the image that is so often sold to us is of the struggling artist. You know, the writer shivering in a garret, just trying to leave a little something for their grandchildren.
That is the narrative, 100%. Do it for the poor poet.
But our source suggests that the chief architects of this change were not starving artists at all.
No, not even close. Kinqade points the finger directly and unequivocally at the publishing houses, the major record labels, the movie studios, the corporations.
Why them? I mean, why would they care more than the individual artists?
It's simple. Because they're the ones with the massive back catalogs. Think about the economics of a big publishing house. They have thousands and thousands of books in their library that were written decades ago.
A backlist.
Right, the backlist. If you're a publisher, a huge chunk of your annual profit comes from books that are already written, already edited, already typeset. All you do is keep printing them and selling them. It's almost pure passive income.
And if those books enter the public domain,
then anyone can print them. Penguin Classics can print them. Dover Thrift Editions can print them for $1. You could print them in your basement. The price plummets to near zero. And the publisher loses their exclusive monopoly on selling, say, The Great Gatsby or The Sun also rises.
So it wasn't altruism toward writers that drove this. It was a cold, hard desire to protect revenue, protect profit, and protect their distribution channels. They wanted to keep the gate closed so they could keep charging everyone the toll.
Precisely. But here's the really tricky part. You can't just go to Congress and say, hey, we are a massive faceless corporation and we'd like to stay rich. Please change the law for us.
No, that doesn't play too well in the evening news. That just sounds like greed.
So as the source explains, they used a very clever narrative spin. They sold this new, incredibly restrictive regime as fighting for authors' rights.
Ah, the moral cover.
That's the term. They trotted out the authors, or more often, the author's elderly children or grandchildren. And I said, we are doing this to protect the creators. We are ensuring that the people who make our culture can feed their families.
It's a brilliant marketing tactic.
Yeah.
I mean, who wants to vote against the poor, struggling author? It's like voting against Bambi.
Nobody. But the reality, according to our source, is that the authors were essentially human shields for the corporate balance sheets. The publishers were the principal beneficiaries of all these extensions, but they used the author's moral standing to get the laws passed.
However, and this is where the source gets a little spicy, it doesn't let the authors off the hook entirely.
No, it definitely does not.
Because it asks the question, are authors just innocent victims here? Are they just being used by these big, bad corporations?
And the answer the source gives is not really. It complicates that simple narrative by pointing out that, greed is a pretty universal human trait.
The corrupting force of greed. That's the exact phrase used.
Yeah. Many authors, or more accurately, their estates, were perfectly happy to go along with this. They also wanted longer terms. They also wanted a larger slice of the pie. The source explicitly blames a lust for money that drives both sides of the equation.
There is a specific argument mentioned in the text that I found both hilarious and tragic at the same time. The dead author argument.
Oh, yes. This just highlights the absolute absurdity of the whole thing.
So when the copyright terms were extended in 1998, they didn't just apply to new books, they applied retrospectively. They extended the copyright for books that had already been written decades ago.
Right. They moved the goalposts on works that were already in the game.
And many of those books were written by people who were already dead.
F. Scott Fitzgerald, Hemingway, George Gershwin, they were long gone.
And the source just bluntly states, dead authors do not need incentives to create. They are dead.
I mean, it's irrefutable logic, isn't it? You can't incentivize a corpse. If the entire constitutional purpose of copyright is to encourage people to write more books, to promote the progress, then extending the copyright on a book written by a guy who died in 1940 achieves absolutely nothing. He isn't going to wake up and write a sequel to Gatsby.
But the copyrights continue. They just march on like zombies.
They do. And that is the ultimate proof that the system isn't about incentive anymore. It's about asset protection. It's about maintaining a revenue stream for people who did not create the work in the first place.
So we have these incredibly long terms. We have this corporate stranglehold. But I want to bring this down to the ground level for a minute. How does this actually affect a writer who's working today, someone who is alive and trying to create something new? And that brings us to section 4. The fiction writer's dilemma.
Yeah, this is where we get into the nitty-gritty of storytelling mechanics.
The source mentions an essay called A Question of Plagiarism, and it brings up this concept of the ocean of prior art. I love that image.
It's beautiful, isn't it? The idea is that no story is truly 100% original. Every story we tell draws from this vast ocean of things that came before it.
There are only so many plots in the world, right?
Exactly. There is the hero's journey. There is the love triangle. There is the murder mystery. There's the coming-of-age story. These are archetypes that are thousands of years old.
The source calls them the vocabulary of storytelling.
Yes. And you can't own a love triangle any more than you can own the letter A or the color blue. These are the fundamental tools we use to communicate. If someone could copyright the concept of boy meets girl, the entire romance genre would just cease to exist.
So, in a sane world, you can't copyright a plot idea. You can only copyright your specific words, your expression of that idea.
That is the legal theory. It's a famous legal principle called the idea-expression dichotomy. Ideas are free for everyone. The specific expression of those ideas is protected.
Can you give me a concrete example of how that's supposed to work?
Sure. Let's take Harry Potter. The idea is an orphan boy discovers he is a wizard and goes to a special boarding school for magic.
Okay, pretty common trope.
J.K. Rowling does not own that idea. That idea has been around for a very long time. The Worst Witch, A Wizard of Earthsea, Wizards Lots of Books have that basic setup.
So I can write my own book about a wizard school.
Theoretically, yes. But here's the problem. The expression is protected. Harry Potter, Hogwarts, Quidditch, Muggles. Those specific words and highly detailed characters and settings are owned.
That seems fair enough. I shouldn't be able to just copy and paste your book and put my name on it.
Of course not. But the source argues that this line, this critical line between a general idea and a specific expression is getting blurrier and blurrier. It's eroding.
How so?
Because of a legal concept called substantial similarity. If your character is deemed too similar to another character, or if your plot beats follow another book too closely, you can get sued for infringement. Even if you didn't use the same names, even if you wrote every single sentence yourself from scratch.
So if my wizard boy has a distinctive scar or a specific kind of magical enemy, I'm suddenly in the danger zone.
You are in a legal minefield, and because the copyright terms are so long now, everything is owned. In 1790, you only had to worry about books written in the last 14 years. Today, you have to worry about every book, movie, and TV show written in the last century.
That creates a chilling effect on creativity.
A massive chilling effect. The source mentions that authors today have to be incredibly careful. Some even hire lawyers, they call them forensic editors, to review their manuscripts, just to make sure they aren't accidentally stepping on a corporate toe.
That sounds absolutely exhausting
Yeah.
and expensive. I mean, most indie writers can't afford a forensic editor.
No, of course they can't. So they self-censor. They avoid certain topics. They stay away from anything that smells like it might be owned by a big company.
It's just so ironic. Remember, this whole system was sold to writers as protection. We're protecting your rights. But now it's actually constraining their creativity. You're constantly looking over your shoulder, wondering if Disney or the Tolkien estate is going to come after you.
You're scared to use the building blocks because someone, somewhere, claims they own the patent on the blocks.
So that's the impact on the creators. But what about the rest of us? The audience, society. This brings us to Section 5, the tragedy of the public domain.
And the source uses a very evocative term for this. It calls it the public domain famine, or a drought. Because of these repeated retroactive extensions, especially the big ones in 1976 and 1998, we essentially froze the public domain in time.
Can you give us a stat on that? How bad was it?
The source notes that virtually nothing published after 1928 entered the U.S. public domain until just very, very recently. For decades, the line just stopped moving. Every year, January 1st came around, which is traditionally Public Domain Day, and nothing new became free.
So we missed an entire century of cultural recycling.
We did. Think about how much culture shifted between 1928 and, say, the year 2000. Jazz, the Beat Generation, rock and roll, the golden age of Hollywood film, the rise of modern science fiction, all of that was locked up tight. We couldn't remix it. We couldn't freely adapt it. And in many cases, we couldn't even properly preserve it.
Preserve it? What do you mean?
That's a huge, often overlooked part of this. If a book or a film is under copyright, a library or an archive can't just digitize it and put it online for everyone. They need permission. And very often, the publisher has gone out of business, the author is long dead, and nobody has any idea who actually owns the rights. It's called an orphan work. So the book or the film just sits on a shelf and physically rots away because nobody has the legal right to save it.
That is legitimately tragic. And this brings us right back to what the source calls the Disney paradox.
The hypocrisy is just stunning when you lay it all out.
I mean, Disney built its entire empire on the public domain, didn't it?
It absolutely did. Cinderella, Snow White and the Seven Dwarfs, Sleeping Beauty, The Little Mermaid, Aladdin, Frozen, which is based on Hans Christian Andersen's The Snow Queen. These were all folktales. They were in the public domain.
So Disney took them for free, adapted them, put their own unique stamp on them, and made billions of dollars.
Which is great. I mean, that's exactly how the system is supposed to work. Walt Disney took the old bricks, Grimm's fairy tales, Andersen's stories, and he built a beautiful new castle.
But then, once they had built their own castle, they turned around and spent millions of dollars lobbying to ensure that no one could ever do the same thing to their stories.
They pulled the ladder up right behind them. They utilized the cultural commons to become powerful, and then they used that power to enclose the commons to stay powerful.
And this, the source argues, created a new class of people it calls rentiers.
The rentier class.
This isn't a term you hear every day. It sounds kind of French and fancy. What does it mean in this context?
A rentier is someone who derives their income from property ownership rather than from their own active work. In traditional economics, it's usually landlords who own a lot of property. In this cultural context, it refers to the estates and the heirs of long-dead authors.
People who didn't actually write the book.
Right. Imagine if the guy who built your apartment building died in 1940. But his great-grandson, who has never held a hammer in his life, who doesn't know the first thing about construction or plumbing, can still evict you or double your rent just because of his last name.
That's the rentier class in culture.
Exactly. They didn't write a single word. They didn't edit a page. But they feel entitled to reap the profits indefinitely just because their grandfather happened to write something famous a century ago.
And the source uses The Great Gatsby as the prime example of this.
It's the perfect example. The Great Gatsby was published in 1925. F. Scott Fitzgerald died in 1940. And he died thinking he was a total failure, by the way. The book was not a big hit in his lifetime.
So tragic.
And under the current rules, the copyright on that book didn't expire until January 1st, 2021.
So for 81 years after he died.
81 years. His estate people, who were not F. Scott Fitzgerald, controlled that book with an iron fist. They decided who could make a movie. They decided which publishers could print it. They decided if a high school play was allowed to perform an adaptation. And they collected all the checks.
That is a very, very long time to be paying rent on a single story.
It treats stories like they're real estate. like a landlord collecting rent on a building they just inherited. But stories aren't buildings. They are our shared cultural artifacts. They're meant to be shared and passed on and built upon.
So we've established we have a broken bargain, we have a famine, we have these rentiers. It all feels pretty bleak. Is there a way out of this, or are we just stuck with this system forever? Section 6. The way forward.
The source does offer a path forward, and it starts by clarifying what the solution is not.
It's not about abolishing copyright entirely.
No, definitely not. The author, Kinqade, is very clear on that point. This isn't an argument for anarchy. Creators deserve to be compensated. If you write a book, you should be able to sell it and feed your family. That's totally fair. If you spend 5 years of your life writing a novel, you should own it for a while.
So what is the solution then?
It's about restoring the original bargain. It's about returning to reasonable terms and having a system of robust, fair use.
Reasonable terms. Okay, let's paint a picture. The source invites us to imagine a kind of what-if scenario.
Right. A thought experiment.
Let's imagine if we actually went back to the original idea of a 28-year term. Or, maybe even something slightly longer but still limited. Let's say a 50-year maximum term. No life plus anything, just a flat, predictable term.
Okay, let's play that out. If the term was, say, 28 years, what would be in the public domain right now?
Well, 28 years ago was, let's see, 1996.
1996.
So the movie Independence Day. Mission Impossible. The first Spice Girls album. The first book of the Game of Thrones came out right around then.
Wow. Imagine if all of that was free for anyone to use.
Imagine young writers today being able to legally write and publish their own stories set in the Game of Thrones universe without asking HBO for permission.
Fan fiction wouldn't be this legally gray market thing that lives on obscure websites. It would be a legitimate literary practice. You could publish it. You could sell it.
Scholars could digitize everything from the 1990s and put it online for free.
Yeah.
The entire cultural output of the late 20th century would be searchable and accessible to every student on Earth.
Remix culture would flourish. You could sample music from the 90s without having to clear those samples for thousands of dollars. You could make video essays using movie clips without the constant fear of getting a copyright strike from YouTube.
It sounds like a creative explosion.
It would be. It would be a cultural renaissance. And it requires a big philosophical shift. The source says we have to accept that, in a way, we are all plagiarists.
That sounds provocative. I mean, nobody wants to be called a plagiarist.
He uses the word a bit loosely, of course, but he means it in the sense that we all draw from the same wellspring of culture. We all stand on the shoulders of giants. And that is not a bug in the system. It's a feature.
It's just how culture works. Culture is a conversation. You say something and I respond to it. If I'm legally forbidden from repeating your words in order to respond to them, the conversation just dies.
Exactly. The choice we face, according to the source, is between a legal system that pretends stories are private property to be hoarded forever, or a system that recognizes them as our shared inheritance.
So, as we wrap up this deep dive, let's just try to summarize the journey we've been on, because we have covered a lot of ground here.
We started with a simple, elegant vision of a limited-time monopoly, 14 years, designed specifically to promote progress. A deal between the creator and the public. I give you a short-term monopoly, you give society a permanent library.
And we watch that deal get completely broken, transformed over a century into a 95-year asset protection scheme.
Driven by publisher profit, disguised as a fight for author rights, and fueled by that universal lust for money.
And the result is that we are living in a culture that is largely owned by corporations and the estates of dead people. We're experiencing a famine of the public domain.
It's a harsh way to put it, but it's pretty accurate based on the source material.
I want to leave our listeners with one final thought to chew on. You mentioned a quote earlier from Justice Stephen Breyer.
Yes. This was from his powerful dissent in the case Eldred v. Ashcroft, which was the Supreme Court case that challenged the 1998 copyright extensions. He lost the case, but his dissent is legendary among copyright scholars. He wrote, "The monopoly granted to authors is for the benefit of the public, not for the benefit of the authors."
With the benefit of the public,
yeah.
It flips the whole script.
It really does. We usually think, oh, copyright exists to help the author. Breyer says, no, copyright exists to help you, the reader. The author only gets paid because that's the best way to help you get a new book.
So here's the question for all of you to mull over as you go about your day. If this system is meant to benefit you, the public, Why does it so often feel like you're just a tenant in a culture that's owned by someone else?
Right.
Why do you have to pay rent to visit the stories that define who we are?
It really raises the question, are we citizens of our own culture or are we just customers?
That's the question. Thanks for diving deep with us.
See you next time.